Thanks.
Thank you, Rob. I am Allison Conch. I'm the program manager for CERC. We are here today to do part 3 of a 3-part webinar on due process. So if you missed the first 2 parts, those will be posted to the website soon, those recordings, as will this after today's session, sometime later this week, most likely. So today, Joanne Blades, former program manager and assistant director of CERC, will be leading us through this 3rd part, specifically on the actual hearing after due process is filed. And both me and Sharon Long, the executive director of Oklahoma Parent Center, will be kind of asking questions throughout the process. So Joanne, I will share my screen if and when you're ready to take us away.
Okay, great. So happy to be here today. We are doing this series as a way to try to make due process not such a mystery. It is a very complicated process, and because of that, 3 2-hour or 3 1.5-hour sessions really isn't a lot. So I'm trying to give you the overall picture through the 3 webinars to kind of make it so that it's not so scary. It is a very difficult process. It is a very legal process. And we know I was 18 years leading CERC. And even as an attorney, I worked with parents to help them kind of understand the process. And it is I never heard it was a fun process for anybody, not a school or a parent. But it is a hearing that sometimes you need to have. And we want to be able that we provide some resources that would help parents feel more comfortable if they are find themselves needing to file it on behalf of their own child without the assistance of an attorney. So this is the 3rd webinar. As Allison said, we're hoping that all 3 of them will be able to be posted on our website next week. And this webinar is specifically dealing with actually what happens at the hearing. So next slide, Allison. I kind of want to go over a little bit of what we talked about last time, and just by a segue of preparing for hearing. It is not easy. Some parents feel like they file the hearing and, I filed a due process, I'm done. You are just starting the journey. So it's really important that you understand that you're keeping an eye on the ball, that you're moving forward with where you need to go with this, because there is a lot going on. Once you file, you have initiated a legal process. If you're pro se, which means you are representing yourself, you will be dealing directly with the school district attorney. And sometimes that is a little bit frightening. That's why we encourage you to call CERC. CERC does not give legal advice, but they can explain some terms to you. They can explain what the process looks like. And of course, I think in the future, they'll be referring people to these webinars. But getting properly prepared for the hearing makes the hearing go much smoother. And properly prepared encompasses a lot of things. One of the biggest things is getting your 4 copies of evidence in notebooks. As you know, we talked about in our last session, you have to have 4 copies of the evidence. We ask that they be in notebooks, tabbed. You can make your own tabs. We can tell you how to do it a little cheaper than going out and buying expensive tabs. And each copy of evidence have to be numbered. They're also listed, and a list of the witnesses is required, and all of that is exchanged 5 business days prior to the beginning of the hearing. You really need to have your subpoenas out as early as you can possibly do it for people that are not employed by the school. If somebody you want to call as a witness to testify is employed by the school is required to present them. But if the school doesn't have control of them, you have to serve a subpoena. We have copies of those in our due process guidelines, so we can tell you what they look like. And actually, you could print it off and fill in some blanks and would probably be okay. We have subpoenas for witnesses, also subpoenas for documents if you need that. And then to get ready for the hearing, you really need to understand how the hearing is going to proceed. Once you get there, what is going to happen during that hearing? And that's really the heart of what this webinar is about. Next slide. Okay, and I think I probably said this. Any questions you have about the process, you can ask CERC. If it's an issue that's controlled by the hearing officer, you need to bring it up in a pre-hearing conference, or you can email or contact the hearing officer with questions, and as long as you copy the school district or the other party. Now, I keep referring to most of you as parents. Sometimes schools file due process. There's a few limited reasons that we talked about that a school could file, but most of the time, the person filing the due process is the parent. So I kind of tend to talk about it in that way. We are generally going to be talking about what happens in a regular due process, and occasionally you'll hear me mention an expedited. And of course, in a prior one, we went over what an expedited hearing is as compared to a regular due process hearing. Keep in mind that CERC cannot give you a choice. In other words, they can explain and you have to make the choice. They can't tell you what is best. And also, they can't really give you legal advice. They can't talk to you about what standard it is that you're looking for, or they can't tell you how the school has violated or not violated. They may try to give you a little guidance of things to look at, but those are not things they do. Next slide.
I'm glad you said that, Joanna. I'll say sometimes, I've already had parents call through this process and ask, well, what should I do in this situation? Do you think I should do blah, blah, blah through a due process filing? And all I can do is say, if you do this way, here's what will happen. Like, here's what the timeline will happen, or here's what then that will make the school do. If you do this way, here's what will happen. And then it's up to the parent to decide, because we want you to make fully informed decisions, but that's all we can do is provide information on the process.
Yeah, and you may have a personal opinion about what you would do, but it's not your place. I mean, the parent has to make those decisions for themselves and their child. Okay, good comments. Next slide. Okay, the hearing officer. What is the role of the hearing official? Hearing officers control all aspects of the hearing. Now, the rules of the hearing and how it's set up, the timelines, what kinds of things happen, it's all set in federal law. CERC does not have control of that. The state of Oklahoma does not have control about that. We must do the basics of what is required through the people who monitor our systems, which is the federal law, and also OSEP, which is the Office of Special Education Programs. They do monitor our system, and they will look at things of, why have you given extensions in the hearing? They look at all of that and find the program to be in compliance or out of compliance. So we do follow OSEP guidelines. But as far as actual hearing, the hearing officer is the person in control within the parameters of those laws. And they ultimately decide what issues they can determine and hear. And that's because I'm going to say we, because I was there for 18 years. The hearing officers, we call it this administrative procedure, a court of limited jurisdiction. So there are only certain things that hearing officers can hear. They cannot hear things that would go for discrimination, for instance. Frequently, those are issues that parents are pleading. But if it's not related to one of the issues we talked about, you could file upon, it's going, like if it's a discrimination claim, they will tell you that if this is a discrimination and the way you've pled it, this is discrimination, we cannot hear this. I don't have jurisdiction. That's because discrimination issues alone are heard through the Office of Civil Rights, the U.S. Department of Education, and through 504 hearings. So under IDEA, it is confusing. It's like I always joke, the wisdom of the federal government put IDEA under the U.S. Department of Ed, and then they put all the discrimination issues under the Office of Civil Rights in the U.S. Department of Ed. And really, IDEA is based on a lot of those discrimination statutes if you go back and look at how the law evolved. And, that's law nerd stuff, but it is kind of confusing to people. Now, the hearing officer is to be disinterested, meaning not to be emotional during the process, to be forthcoming about what's required. They're very judicial in the way they handle things, and they will listen to the testimony given. They read the briefs, they look at the evidence, they listen to the people that are testifying, and they will look at that information that's only necessary for the legal standard of the issue you've brought forward. And that again is something we talked about in an earlier webinar. This is probably the place where I see parents having the most problem is they don't understand the legal standard. And we'll talk a little bit about legal standards a little bit, and we're going to have some examples here coming up. And the hearing officer will weigh the evidence, and they will make something called a finding of fact. There will be more than one. It's depending on how many issues they are, but they have to listen to the webinar and then they weigh the evidence. So they will make a finding as to what is a fact of law. Not a fact of law, but just a fact of what happens. The child was categorized as emotionally disturbed. It's a finding of fact, or things that they see in the record, things that they have, they will make these findings. And with those findings of fact, they're going to create a rationale for applying it to the facts of the legal standard. And that's kind of legal language, and I understand that. I know it's the attorney in me. It's really hard for me to figure out a way to say that without just giving it to you legal. Allison, are you going to jump in and ask me a question?
Yeah, I was just going to ask.
She's going to. Yeah.
Yeah, I was just going to ask about is there an example that you could to make it better, more understandable?
I'll give you an example, like a legal standard. The Supreme Court in the Rowley case and the Andrew case came up with a general standard on how do you determine if FAPE was provided. And the courts have said in those two cases, it is an IEP reasonably calculated at the time it is written. Now that really comes from a 10th Circuit case at the time it is written, but an IEP reasonably calculated at the time it is written to provide some educational benefit in light of the child's individual circumstances. So that's not bright line. That's kind of hard. They make it so that it's flexible to meet every child's issue. And when they added that terminology in light of the child's individual circumstances, they did that because the circumstances of children vary so much. So it's not going to be the same for every child. It's going to be an individual inquiry. So an example of this might be if you're alleging that the IEP that was written was not reasonably calculated for the child to provide some educational benefit, then they're going to be looking at that kind of testimony. Things about what were the goals? What was the child's performance? What do evaluations, state testing, school testing, what do all these things tell us about how much progress the child is making? Does the child have to make progress in every area? No, they don't, not for some benefit. And I've talked about this in a former webinar, but I feel like I have to say something here, that the law does not say that the schools are required under law to maximize the child's benefit. They have to create a program that allows them access to their education so that they receive some educational benefit. And that benefit is in light of their individual circumstances. So sometimes we see parents who complain because they say this IEP is not rigorous enough. These goals, the way it was written, it's not providing enough benefit to my child. And maybe they're saying, my child is in 6th grade and they're still learning to identify their numbers, and that they should be getting 6th grade level math. Well, the hearing officer is going to limit the testimony. They don't care. I mean, it's not that they don't care. They're not considering other information given. Like one time I had superintendent tell me he was really frustrated because testimony came out in his hearing years ago about the parent was testifying how many times he had seen his truck outside a local bar. Well, that has nothing to do with the child. So the hearing officer would limit that type of discourse. If you're complaining that someone's not nice to you, or I didn't like the way they rolled their eyes in the meeting, they're not going there. They're going to what is the legal standard? What is it that the filing party has to prove? What are the facts? And it's going to be narrowly tailored, those facts, to what they're trying to figure out. Was some benefit given? What were the child's individual circumstances? So if a child is, let's say, has a gifted IQ and their goals still are saying that they need to know their numbers through 1 through 10 and they're in 6th grade, well, that's obviously probably not going to be reasonably calculated. So it's going to be different for each child. If that child was severely intellectually impaired, and maybe that child is still learning their numbers from 1 to 20, they may find, based on testimony, that learning the numbers 7, 8, and 9 is appropriate goal for that child based on their individual circumstances. So everything in that standard is an IEP reasonably calculated to provide some educational benefit in light of the child's individual circumstances. That's one standard of many, many. We're not here that's the main standard I think people learn. We don't really train on standards because that's more of a legal issue. Okay, next slide.
That's helpful to understand, Joanne. They're using the findings of fact for that in the specific case to create a rationale for that specific child to then look at whatever standard is being filed on. Kind of.
Right.
Okay.
Right. And at this time, by the time you get to hearing, I'm just going to say, oftentimes the parties don't get along. The parents real angry with the school may be tired of the parent, and there's just so much conflict embedded in things that people want to talk about things that don't have anything to do with what the standard is. And the hearing officer will limit testimony, or they'll, and we'll talk about that in a minute. Okay, next slide. Okay, so the role of the hearing official. The filing parties and the responding parties do not direct the hearing officer. The hearing officer controls the hearing. And I say that because occasionally we'll have a parent that will tell the hearing officer, we don't want you to do this, or we don't want you to do that. And there's certain things, they are like a little judge, in this administrative hearing, and they will determine, they have to conduct it based on rules, and they will determine and make decisions how it's going to proceed, because they have to make it proceed in an orderly fashion within certain timelines. There's certain rules that they are conducting it within. So they will be very straightforward with you, but they make the scheduling order. They make the decisions about what's going to happen in the hearing. An important thing to tell you is that hearing officers do not investigate your claim. And that sometimes I think is something that faces pro se parents in a difficult way. It's not uncommon in the last 18 years for us to get a due process filed by a pro se parent that says, my child has been denied FAPE because I don't like the work that he's given in school. And then they attach and see 500-page of evidence. Well, the hearing officer is not going to go through the 500 pages of evidence and figure out what's wrong with your case. You have to tell them. You have to tell them, and we kind of talked about this in an earlier webinar, but you have to tell them what's wrong, what is the legal standard that's been violated, and it has to be one of the issues that we talked about, one of the 5 issues that's set out in the IDEA that you can bring a case about. And so it's really the responsibility of the person filing the case to establish evidence and testimony to prove the legal standard. And the hearing officer doesn't go looking for it. That's a little bit different than a state complaint. And I think that also is confusing to people because state complaints, formal state complaints, they have a completely different standard. They are the State Department coming in, investigating an issue alleged by a parent, and they are determining if the school followed proper procedures, did the things that they were supposed to do during their work, and they're 100% compliant. And so you could get a state complaint where there was a finding of something wrong. Not all the teachers attended the IEP meeting. Not all the teachers signed the IEP meeting. Somebody signed that wasn't there. Those would be found as out of compliance issues 100%, not necessarily in a hearing. And we'll talk a little bit more about those differences coming up.
Hey, Joanne.
Yeah.
This is Sharon. I just want to add, it's so important about the preponderance of the evidence, that to prove it. That's so important. We go over with parents all the time. Without a paper trail, it didn't happen, and how they need to keep a paper trail, and also written notice, how important it is, because that is your evidence a lot of times.
When something happens and you ask for written notice of why they have refused, the school has refused something, or why the school is proposing something, that does document in their school file in the record as to why something happened. And that can definitely be submitted as evidence. All of those things, that paper trail is part of your evidence. Yeah, it's great point. So it's the person filing the due process that has the responsibility to prove the violation of the law. The school doesn't have to prove really anything. In law, we call it shifting the burden. So it's like the parent makes a filing and says, this IEP was not reasonably calculated to provide educational benefit because the goals were not reasonable in light of the child's academic abilities or whatever. And then the school district doesn't have to they'll defend against that, but they will simply be putting on evidence as to what they did do, what the child's academic levels were, all of these things with their theory of the case. So I don't know if that got too legal, but just remember, I think the bottom line is the parent attorney, and parent attorneys, they understand all this. This is part of legal practice. So it's the pro se parents that have really struggled with this. And I understand that. I totally do. I was a parent raising a child. The hearing officer will not be ruling on their opinion of what happened. So that's important too. That's why talking about who rolled their eyes in the meeting, who was mean to each other, who did this, who did that, why they're angry with each other, whether the school is testifying about the parent, whether the parent is testifying about the school, they're going to limit that testimony out. Because however that hearing officer feels about something, their personal opinions don't matter. Their job is to look for the evidence, verify that evidence, and show how it meets the legal standard. The party that's unhappy with their decision can appeal it to a higher level, all the way up into court. And I always say federal court, it can go to state court, but I can tell you school district's going to move it to federal court every time. That's just the way it is. It's a federal law and they're probably going to be moving it. So it can even get a court review. So the hearing officer is going to be very careful to show the rationale for their decision. They're to cite to the evidence in the record, to show the documents that support their findings of fact or the testimony. They can make credibility determinations when testimony is conflicting. And sometimes there is conflicting testimony. And the hearing officer has the ability to decide who they believe and why based upon the credibility of the parties. And they can also put that in a hearing decision. Okay, next slide. It is so important to read the due process guidelines. I just can't tell you how important this is. We are in the process of redoing them. We have been for a while. But those due process guidelines can be found on our website, the CERC website, under the due process. You just look for due process hearing guidelines. Read them carefully because they tell you what they need you to do. They have sample forms. Those forms are in the process of changing. That's why we're changing the booklet. And there's also appeal forms so that if you don't like the decision, you can appeal it to another level in the hearing process, the appeal process. But it's so important to know those due process hearing guidelines. I tell parents it's better if they know all this before they file, because we frequently see pro se parents file a due process and then they are so overwhelmed by the emotions of it, by preparing for everything. It has really been reported to me on every occasion. I've never had any parent, even a parent who has won a due process, does not tell me it was a good process. It is emotionally draining. It is, I mean, your hands are full raising your child. But sometimes, and parents can't all afford attorneys, nor can you always find an attorney who represents parents. But it definitely, when it has to go, it has to go. And we do have parents who are successful in their claims. So, you know, it's just that we want you to be informed and to know what you're getting into before you just file the paper, because it's not really that easy.
It is tricky because it feels like it's easy, like you said at the beginning, to file it. You think I filled out these 2 pieces of paper, and now
Yeah,
I'll never
I'll
read
never
the guidelines. It's 60 plus pages, so read that before you file.
Yeah, and I remember one time I was training school districts about different things on educational issues, and a district, I think it was a special ed director, raised her hand and said, "Can a parent just download a form, fill it out, and file a due process?"
Yeah.
And I said, "Yeah, pretty much. That's what they can do." Now, sometimes it makes the process a little bit more frustrating, but we really encourage you to know about the process. You have a 2-year statute of limitations, and we really encourage people to figure this out before they file if they can. Okay, next slide. This is just general information about the hearing and the hearing process itself. A due process hearing is an informal administrative hearing. It's sort of convened like a trial. It's held at the school. Oftentimes it's in the board meeting or into a conference room that is separate. Generally, there could be a table where the hearing officer sits at, and then 2 tables on the side, just like you would see in a courtroom, you know, one side with the school on it, one side with the parents on it. And then there's a court reporter that's transcribing everything they have. And what they transcribe is what we call the official record. Again, this hearing process is generally set by procedures under the IDEA and Section 504 to ensure that those civil rights of being able to exercise your procedural safeguards are ensured. And that's what the hearing officer is doing too, ensuring that your procedural safeguards have been done. And we'll talk about what that looks like in a minute. The purpose of these hearings is really to gather all the appropriate information regarding the issue. And it was designed as a way to try and resolve disputes prior to taking it for a true court case. So the judges in the courts do look, they read if it goes on to appeal in federal court, they do read the transcripts, they do look at all the pleadings, they read the motions, they read everything that the parent has filed, everything the school has filed, the briefs, the evidence, they look at everything, and then they make a decision based on whether the hearing officer, it's called a modified de novo review. So they can overrule a hearing officer, but generally if the hearing officer has followed all the rules and cited well to the evidence, that gives them a good basis to start from. And so that's why the hearing officers are very careful how they do things during that hearing, because they are preparing a record that will go before a federal judge eventually, or possibly a state court judge. During that hearing, witnesses are removed from the hearing room, the ones that are waiting to testify. And we call that sequestration, sequestration. And it means that they're not there to listen to everything in the hearing. if they're going to testify, they can't hear everything that's been going on. Now, that isn't true for parents. Or because like, you know, how you think of the trial at one table, you know, it's like you see on Law and Order, you know, there's one table with the attorney and the people that are there and the other table. So the side that has the parents might be an attorney with the parent representatives. It might just be the parents, but those people will be able to remain, hear the testimony, and testify because they are the filing party. And they are what we call the petitioner. And the other side, you have like the school district attorney and a representative of the school district. It might be a superintendent, it might be a special ed director, whoever is there. Those people can listen to the entire hearing too. But other witnesses, teachers, private providers, psychologists, anyone that is called to testify, they will not be listening to the hearing before testifying. Now, if they're not going to be called anymore, they can listen. They can come in and listen to the rest of the hearing as long as they won't be called. But if they haven't testified or they could be called back, then they cannot come and listen to the rest of the hearing. That's to keep it fair for both sides. So you're getting their clear testimony. Okay. Now this is a little tricky. This is a little bit legal, but I couldn't think of a way to give it to you any different. I'm just going to put it out there the way it is. Federal law says and dictates that the decision made by the hearing officer is made on substantive grounds based on the determination of whether the child received a free and appropriate public education. Now, that may not mean anything. I'm going to try to explain this in a little bit. In the second part is, if the matter is alleging a procedural violation, then the hearing officer may only find that a child did not receive FAPE only if that procedural problem impeded the child's right to FAPE, significantly impeded the parent's opportunity to participate in the decision-making process regarding the provision of FAPE, or caused a deprivation of educational benefits. So you're probably asking, what does this mean? It means that, you know, before 2004, a parent could bring a case that said not all the required teachers were in the meeting. That's a procedural violation and my child has been denied FAPE. There were actually cases that found that a child was denied FAPE because they hadn't followed the proper procedures. But in 2004, the hearing officer now will find that those procedural errors, somebody forgot to sign the IEP, somebody signed the IEP that didn't come, it will be a harmless error unless the parent can show that failure to do those procedural things impeded the child's right to FAPE, significantly impeded the parent's opportunity to participate, or caused an educational deficit, a deprivation of educational benefits. And one of those examples might be, okay, the reading teacher didn't come. So the hearing officer is going to say, okay, that may be a procedural violation. They would look then, again, because they're going to look at the evidence that's right there on the standard. What was that teacher there to share with the team? If that teacher was there to share maybe something about the child's reading and the child is not making progress in any of the ways they've tried to address it, the child has all these deficits, then the hearing officer might say, well, had she attended and told that to the team, something different would have happened. And they would have to specifically make those findings. Those are findings of fact. The teacher did not come. The teacher, if she came, would have testified to this. The failure for that testimony caused the team not to address new ways to solve that problem. You know, there has to be that continuum. This is kind of a legal standard in of itself if you're providing complaints about a procedural violation. So a common procedural violation is, I didn't get notice of the meeting. That's one we hear a lot. Well, the hearing officer would say, okay, notice was not given. And then they would look and say, did you go to the meeting or did you not go to the meeting? Well, I didn't even know about it. Nobody told me, I didn't go. Well, that may significantly impede the parent's opportunity to participate. If you didn't get a notice, but you went to the meeting, the parent was not significantly impeded. Okay, unless they can come up with a reason why they would have been.
Because Joanne, you're differentiating between, they might have gotten an email notice that like, hey, we're still meeting tomorrow at 10 a.m., but the district forgot to send like the formal invitation, that IDEA paperwork. So they
Yeah.
knew about it and came, but this procedure wasn't followed, which would not have impacted their ability to participate.
Yeah, and they would have found it was a procedural violation that was harmless error. Okay. So there can be problems with procedural violations that do cause a problem. But if a parent is alleging that the procedures were not followed in some way, they have to show how it manifested in a problem, how it impeded the child's right to their education, how it significantly impeded the parent's opportunity to participate, how it caused a deprivation for educational benefits. Otherwise, they're going to make this on what we call substantive grounds, which means they're going to look at how FAPE was denied, what happened in the child's educational program, as far as the 5 things you can file on: the evaluation, the IEP was not reasonably calculated. It's going to be on the substance of the FAPE denial. And I know that's a little legal. I don't know how to describe it any other way, because this is a legal proceeding and it's gathered by legal issues. But I hope I've given you some understanding here. I know for years when I was teaching, I taught for 15 plus years, I know teachers would freak out. Oh, Mary Lou forgot to sign the IEP, and just wig out, because they were afraid that there would be a due process and they would lose because somebody failed to sign. Well, if the teachers say was there, gave all the input they needed to, but simply didn't sign, left in a hurry and didn't sign, that could be harmless error based on the circumstances. But the hearing officer will look at the totality of the circumstance. So sometimes we have trouble explaining that to parents, that the procedural violation alone. Now, in a state complaint, they would be found out of compliance, because again, that state complaint is the state monitoring the procedures of the school district, and they're 100% compliant. So if they didn't do it, they would be found out of compliance. But it doesn't necessarily mean that it would be the same way in a hearing. There's very much a difference between a state complaint and a hearing. You can win a state complaint, but it may end up you won the hearing if you filed it on the same issues, or it may turn out that you didn't, because they are completely different standards. They are completely different in the way they review things. Another example would be, my child is in speech therapy and she was supposed to have 16 sessions, and the teacher was sick and she missed 3 of them. And you file a state complaint, my child did not get all their speech therapy, and they found, yes, they missed 3 and the school didn't make it up. There's a high likelihood they would be found out of compliance in a state complaint. In a due process hearing, the inquiry is deeper than that. What effect did missing those 3 sessions occur? Did the child still get some educational benefit? Did they make progress? What was the child's standing, even though they missed those 3? And if they find that they didn't make as much progress, or they found something wrong with it, then they'll say, no, that denied the child FAPE. But it's possible for someone to find that even though they missed 3 or 1, 2, 3. Now, if they missed 8, that's going to be harder. 8 out of 15. I mean, I'm just telling you, it's all going to be based on the facts of that child and their progress. But still, it's going to be looked at deeper than they would in a state complaint. So it's really important for parents to understand that difference. So the hearing process, what happens in the hearing? These are the general steps in the hearing process, and I'm going to talk more about them. First, the hearing officer will convene and open the hearing. They will give the parties, both the petitioner, which is the filing party, and the respondent, which generally is the school district, they will each be offered an opportunity to make an opening statement that tells why they believe their rights of their child has been denied. And the respondent can make their opening statement refuting that for their theory of the case. Sometimes people waive the opening statement. I tell pro se parents they can write that opening statement ahead of time and read it. If they're nervous, they will not remember something. It doesn't matter. They just need to have their ducks in a row if they're representing themselves. Then comes the presentation of the evidence and the witness testimony. Then each party will be given a closing statement where they summarize the issue. You see that on Law and Order. If you ever watch one of the Law and Order series, at the end, they're coming in and they're arguing why their case was what they want you to find. Either the guy's guilty or the other side said, you know, mine's not guilty. And that's that closing statement in the end. And then the hearing officer will make some inquiries, officially close the due process hearing on the record with the time and those kinds of issues. And either before they close, probably before they close, the hearing officer will discuss with the parties how much time they want to receive the transcripts of the proceeding from the court reporter, and so that they can cite to the evidence, and the parents and the school can make recommended findings of fact. And like they could recommend a finding of fact that the teacher was not present during this meeting. Her testimony would have been critical to determine that the ongoing services necessary were not provided. Therefore, it was a violation. I mean, that's the finding of fact, okay? And then, and sometimes they write a brief, which is a summary of what their evidence would show and why. And then they set a schedule for issuing the decision. If this creates this timeline the parties want, creates an extension, they have to ask for that extension to allow for these things to happen for their benefit. But they can ask for that so that they can prepare final submissions to the hearing officer for review.
Joanne, this is what we had talked about, I think, in the last webinar, right? Where we had discussed kind of the differences in the timeline requirement versus for a regular due process versus an expedited, and what that sort of looks like, and how the hearing officer, in the case where there is extensions allowed, the hearing officer can't just say, we're going to extend this. It has to come from the request
of the parties. Now, if it's an yeah, that's correct. Okay. And that's why they discuss with the parties the timelines. Otherwise, okay, it all has to be done within a certain time. And that can hinder a parent or a school district if the transcripts come in the day before that they have to have something written, they won't have time. So sometimes they can ask, like, ask the court reporter, how long is it going to take to get the transcripts? Because they have to be signed and verified that they were the actual testimony and all this. It takes a week or two. Sometimes they can get them in a week. Sometimes it's 2 weeks. Depends on how many days the hearing goes. With our hearing reform, we've had shorter days where unnecessary testimony is not given. We've been able to shorten those days, so it makes it a little bit easier. And then depending on the number of issues, if there's a number of issues, there could be multiple days, and it might take longer to get the transcripts done. So yeah, the parties have to ask for a change in the timeline to be able to get that done. Now, in an expedited case that's over a manifestation determination or interim placement during the manifestation determination, those have to be rendered 10 school days, after the hearing. So that's a very quick timeline. But then again, those issues are very narrow. They're just one or two issues, and they're a lot easier to take testimony on, generally. Okay, so what does it mean convening the hearing? So the hearing officer basically is going to begin the official record, and they will often say something like, "We are now on the record." That means the court reporter starts typing, and the hearing officer will introduce themselves. They'll talk a little bit about their function, their role, and their authority. And they will establish if the parent has requested an open or closed hearing. Now, if they can open the hearing to the public, but they will also make a statement of confidentiality that just because the hearing is open to the public does not have the right to see the confidential evidence. They may hear testimony, but they wouldn't be able to see the confidential documents. And that's all based on whether the parent asked it to be open or closed. We see different people do different things. Sometimes I think they think they're going to open it and the whole community is going to come. That doesn't really happen. Trials are kind of boring. But they could, if they wanted to, have other people attend, but it's up to the parents. Some parents want closed hearings because they want the privacy and the individual information that's shared in testimony to be kept confidential, so they keep it closed. The hearing officer would go to each side and ask them, the representatives at that table, whether it be the school district attorney and the school representative, the parent attorney and the the parents that are there, to introduce themselves. They may ask them for their name and their address, being that they want that address in case they have to send them a record of the hearing or their hearing decision or something. Sometimes they ask those addresses later, but at some time they're going to confirm where these things need to be sent. Then the hearing officer will go over the specific reasons that they're trying to find the answer to for that hearing. Then they're going to address any preliminary problems, objections, or questions. This could be something like a parent says, "Well, I asked for documents and I did not receive those documents." Well, it'd be a more specific request than that. Like, "I requested the last evaluation that the school district did on my child, and they did not give me that evaluation." And so at that time, the hearing officer would make a ruling on that and handle it in some way. Or they can answer any questions. Sometimes parties will object to evidence in the other person's notebook. If you've reviewed that, that's why you have 5 days to review. The parents will have 5 days to review the school district attorney exhibits. And there might be something in there they find objectionable for some reason, and they ask that it be stricken from the evidence. And after that's all been settled, to move forward with the hearing, then they're going to give both parties ground rules. And that may be ground rules about, we're going to be taking breaks, we're going to break here for lunch, just any on the conduct of the parties. Oftentimes they will tell you not to talk over each other because the court reporter is trying to transcribe testimony, and that needs to be one person talking at a time. That comes up in hearings where maybe a witness is testifying and the person examining them gets real excited and cuts off their testimony. The hearing officer may stop you and say, "Please, one at a time," something like that. Or if both parties are talking to the hearing officer about something and they talk over each other, they would caution them. So those are kind of the ground rules they would set. Next, the hearing officer is going to ask for questions about due process procedure compliance. And that's really technical, but what that means is they may ask whether or not all the procedural safeguards have been complied with, and they'll go through the list of procedural safeguards. Did you get all the evidence? Did you do this? Did you get a copy of the school's evidence? Did you have this? Did you have that? They'll go through all those questions to make sure that was all complied with. And if there was any non-compliance, they will make a record of it. The parent asked for this evaluation of 4/12/2019, and the school district never provided it to them. And they'll make that on the record. Okay, they have no contempt powers. They can't do anything to people if they don't produce something, but they can make a record of it. I can remember one time when I was an attorney and I was in a due process hearing, and I was a little frustrated because I'd been asking for something and wasn't given it until just 2 days before the hearing. But I did get it. So it was really procedural error because I did get it. And I would have had to allege that I wasn't able to thoroughly review it or add additional witnesses to refute it, something like that. But these kind of things come up. It's all that legal trial stuff. Then they're going to establish if both parties exchange their witness and exhibit list and evidence at least 5 business days before the hearing, or in a expedited case, which has a shorter time frame, in that time frame is directed by the hearing officer. Then they're going to determine if there was a compliance with the 2-year statute of limitations, because due process has a 2-year statute of limitations unless certain things have occurred. And there are reasons that you can get around the statute of limitations. One being that it doesn't apply if the parent was prevented from requesting a hearing because of specific misrepresentations by the school that they had solved a problem, or the school withheld information from the parent that was required to be provided to the parent. So you could extend that 2-year limitation, but it's a technical process, but it's there for parents to go past that. Even though the claims are within the 2 years, they can use evidence beyond the 2 years, if that makes any sense. If a parent was wanting to show a series of things, what had happened to the child, that's just evidentiary as long as it's gone to show a claim that's made that happened, something happened within 2 years. The hearing officer will establish that both parties exchanged evaluations and the information about who conducted them at least 5 business days before the hearing, because the parent could ask a person that conducted an evaluation of the child at school as a witness. And the same with a private party. If they did a private evaluation, the school could subpoena the person doing the private evaluation. It would be a shorter timeline, if it's an expedited case. And then they will make a statement on the record that they'll explain how the decision will be made on substantive grounds. This is the part we talked about, the substantive denial of FAPE as opposed to procedural violations. I wanted to explain that a little bit more earlier so you'd kind of understand it when we got here. Okay, next page. And then there could be an objection to any evidence, and the hearing officer will make a finding of whether that objection is accepted or rejected, and they'll rule upon it. So maybe one of the parties doesn't like evidence in the other party's book, and there's a reason that they think it's not related or whatever, and they can ask for it to be removed. And the hearing officer will make a ruling. And then oftentimes they will ask that all the exhibits and the list of exhibits be admitted by both parties, except for the ones that have specifically been objected to. And it makes for a lot of evidence notebooks. It's not uncommon for evidence notebooks to be 2 or 3 notebooks, big, thick 2 or 3 notebooks. But sometimes it goes easier. It doesn't mean that you have to actually talk about each single exhibit, but you can admit all of the exhibits unless they're objected to.
Joanne, with an
Yes.
objection on what the hearing officer would rule on, is there a certain legal standard for that too? Or is it just like, well, this is related to this claim, so?
It would be whether it was related to the claim.
Okay.
If it had relevance, like they say, I often hear hearing officers say things like, it will be admitted as it is relevant, or
Okay.
it will be considered as it is relevant. It's a bigger violation, I think, when you go to trainings like I have for administrative law. it's a bigger violation. They often encourage the hearing officers to admit it and just give it the weight it's due, which means just admit it and consider it for what level of evidence it really has to apply. Because
Okay.
maybe it doesn't have anything, but why just keep rejecting things when you could just accept it and give it the weight? Weight meaning the value to the
Right.
claim. Yeah.
Joanne,
And
this
again,
is
this is
Sharon.
all kind of legal. Yeah.
Joanne, I have a question. What
Sure.
about recordings, like parents record conversations, which we can in our state? Have you had anybody submit recordings to the hearing officers, or do they?
We have had some recordings submitted. I think we had a suit over some of them, and it went to court, and the hearing officers had said they would let the tapes come in as they were relevant. And the
Mhm.
local judge said that was fine because the hearing officer has complete control of the hearing. Oftentimes we'll ask that you transcribe it.
Right.
I will tell you, you could have a problem in federal court because unless somebody can sign off that that is a true and accurate transcript. So you can have recordings. You can. I mean, potentially down the road, it could be some evidence issues, but there's no problem with having a recording.
So I just know now everybody has a cell phone that can start recording. So 10 years
Mhm.
ago, we didn't have this as much, or even 5 years ago. So
Right. And we
pretty
also,
interesting.
with artificial intelligence, I
Oh,
mean, this
yeah.
is why we're talking about how artificial intelligence really, impacts things, because the idea of all this is to make sure that it's true and accurate. And we're not calling people cheaters. I'm not doing that. But, you could imagine if in the future somebody used artificial intelligence, they say that it can listen to a person's voice for just a little bit and then create something. So, right now I don't think it's happening, but that is a problem for the future. So tape recordings have their own problems. But generally they can be, we ask oftentimes that you transcribe it so that it's easier. It just makes it easier. But a tape recording can be admitted, and then maybe part of that recording, I don't know if the court reporter can certify, they can certify what they heard, but sometimes it's inaudible, but definitely they can bring a
We
recording.
rarely at the parent center, advocate for something like that. But if a district is habitually telling a family, you can't have a written notice, we're not going to do this, or then
Right.
and won't give them the written notice and no response, I think it's very beneficial for families at times.
Yeah, it is not illegal to record. We are in a one
Absolutely.
recording state as long as you are a party to the conversation. It becomes a potential wiretapping charge. Say if you put a recorder in your child's book bag and the child didn't know it and the parent wasn't there to be part of the recording, that could be a problem. But if you are in a meeting and you are the person in the meeting, and if you're going to record, I mean, honestly, I think this is just my personal opinion. I'm not going to say anybody else agrees with me, but I don't know why you can't be up front and everybody get a recording of it, you know?
Because, well, from the parent side, I would say they're going to be more cautious what they tell you. Some of this,
Yeah, if
but
they know they're going to be recorded, they may be more cautious about what they say. Yeah,
yes.
yeah. But yeah, yeah,
Okay. Anyway, thank you,
yeah.
Joanne.
You're welcome. Okay, the opening statement. I'm going to check the time just here a little bit. Okay, we're fine. In the opening statement, each party, beginning with the filing party, the person filing the complaint, they get to present their position in a brief oral statement. And again, you can write it ahead of time if you want to know what you want to say. They want it brief. That means, I don't know, you can ask the hearing officer 5, maybe 10 minutes. They're not going to let you go on for an hour, but you make a brief, and that's your first chance to tell the hearing officer what your case is about. Like, give them the big picture of what is going on here. I'm really concerned because of these things, and I think the evidence will show that this was happening because of this, and this. Now, these statements that people make, they are not evidence, but what they do is they help the hearing officer see the evidence in a picture. So think of it, when I was in law school, when they were teaching us trial, they said, think of it like you're creating a puzzle and your evidence are like puzzle pieces that you're putting in there to show the big picture. So your opening statement is what the big picture is going to show. And then you put in each of the evidences or the puzzle pieces. Is that a good visual?
Yes.
I like that. Your opening
Yeah.
statement, like the picture on the box of the puzzle. Here's what I'm
Right,
going to
right.
do. Yeah.
Like when you see the evidence, and think of a hearing officer too, you open up a box of a puzzle, a jigsaw puzzle, and you throw those pieces out and say, my child had a problem and it's in here. That's the way they feel if you don't tell them what they are. And then you show them the puzzle pieces, okay, that show how this all comes together. Okay, so no objections by the other party can be made during that brief oral statement. So even if the other party doesn't agree with what you're saying, they can't say anything. The school could give up and say something. And please, when the school's giving theirs, the parent should not roll their eyes. And when the parent is giving theirs, the school people should not roll their eyes. I mean, these are things that we see happen when there's a great deal of conflict, people looking off, or, I mean, you need to behave in a mature way and let each party say their part. Sometimes I have talked to parents through the years and they want to hide this piece of evidence till the last minute. There's no hiding. The evidence is either going to show it or it's not. There's no hearing. You learn that in law school. Don't play those kind of games. It makes you look shady. Just put it out there. If your evidence matches up, you're going to win. If it doesn't, you're not. And that's just what you're there to get, that final determination. And a party can pass on making an open statement. So when I did due process hearings for about 10 years, and it was very common that the school district would pass on their opening statement. And that's because they don't have anything to prove. They don't have to prove a thing. They can do nothing. It's the filing party's responsibility to prove the case. So they oftentimes don't give their position in an opening statement. A parent can pass it to the petitioner, but I mean, I personally think you should give your picture to the hearing officer to let them know what the big picture is of the puzzle you're fixing to show them. Okay, then when it goes to the part of presenting the evidence, and that's the testimony and the documents. And the reason you have it in the notebook is so that you can say, the petitioner, the filing party may say, I'm going to call Mrs. Jones, the first grade special ed teacher. And Mrs. Jones goes up there and you may say, Mrs. Jones, could you please turn to exhibit number 7? And they turn to 7, and maybe it's the child's IEP that they wrote. And you would say to them, they would say something like, Mrs. Jones, what is this document? And what you're doing is kind of laying a foundation for what that document is. And they will say, well, this is the IEP for little Johnny written on this date. Have you seen this before? Yes, I wrote this, or yes, I was in the meeting, or yes, I've read it in his file. And then you could ask questions about it, why something was on there, whatever point you had to make. After the witness testifies, then the other party can get up. Like if you're the parent and that teacher's testifying, the school can get up and ask that teacher questions too. And so those questions could be limited by the hearing officer if they're repetitious. If they're asking them the same thing over and over and it's dragging things out, the hearing officer, if it's redundant or irrelevant, and this is an exaggeration, but if he said, Mrs. Jones, what was John's teacher wearing that day? Was it that low cut blouse that showed things shouldn't be shown in school? That would be irrelevant. That would be an objection, but the hearing officer's not letting that in. That has nothing to do with the issues. Those are just kind of questions. And you may laugh to yourself, but this kind of stuff comes up. I'm telling you, people get mad at each other and it's like, look at her hair. You know, I mean, it's the way we are as human beings. But the hearing officer is there trying to keep everybody straight, calm, and be nice. And they are going to be calm. They're going to be very businesslike. And so then after the school questions that witness, the parents have an opportunity. And when they go up and the school questions them, we call that cross-examination. And then the parent can get back up and cross over the cross-examination, maybe ask another question that might change. You've seen that on Law and Order too, where they'll get up and they'll ask another question or another question. It's all a legal process. The hearing officer can ask questions. They may choose not to, but they may have specific questions. I know when I was representing parents in due process, I always liked the hearing officer questions because I could tell if they were getting it or not. Maybe it was something I hadn't really made clear, but they were getting to the heart of what the legal standard was. And I can remember thinking, oh, good, they're getting it. Okay. After, let's see, if at any time somebody raises an issue that wasn't in the due process filing, and this is determined by the hearing officer can interrupt the testimony and then ask the other party if they consent to discussing that issue. Chances are they're going to say no. If the school brings up an issue that's not in there, you're going to be able to say, no, we're not talking about that. I mean, it keeps it, it's supposed to be only what was in that due process hearing due process hearing request are the only legal standards. You can't add them on. Oh, whilst we're talking about this, I might as well tell you these problems I've got. You don't add in the extraneous problems, okay? If the opposing party objects to the introduction, then the hearing officer is not going to let it in. And they will. You would. I mean, most people are. It should all be settled. So you go into that hearing, know exactly, here's our testimony. This is what we're going to talk about. And this is what we're going to do.
Joanne, I have a question about this. With the extra
Sure.
issues or whatever, this is a different situation than, say, bringing up something totally irrelevant, like what the teacher wore or how often that superintendent's at the bar. This is like, if they bring up an issue related to IDEA, then the
Oh,
hearing
yeah, like they said. And like if they said, oh, yeah. And by the way, those goals are not appropriate for my child. Then they might ask the other side, are you going, do you agree that we can take this hearing to the issue of the goals? And the other party's likely to object because they didn't have advance notice. Same thing if the school brought up something and the parent can say, we're not talking about that, that issue. Okay. And after both sides have had their chance to give all their testimony, after the parents do theirs, then the school district can call witnesses. A lot of times, and so they put their witnesses on and their testimony is to refute. So a lot of times they will ask the hearing officer because of, to keep the time limited. If the parent is going to put Mrs. Jones on the stand, then they'll ask, while Mrs. Jones on the stand, when the parent is finished with their questions, can we just do our questions of Mrs. Jones? And the hearing officers often will say yes. And that means it just is less time because then you can excuse the witness. They're done, they're over with. If you wait till the other side, then they have to call them maybe on another day or something like that. So it can go that way too. Is that confusing what I just said?
It didn't confuse me. I get it. What you're saying is typically you go in order of the petitioner's witness list.
The petitioner's witnesses.
The respondents. But if it's the same person, if they both have one person as a witness, you can do it right after each other instead of waiting till the other party brings up their list. Because part of that is they want to get people back in the classroom too, right? And you don't want to keep calling people back over and over.
Right. And that's something that they would bring up in those original issues with the hearing officer that I talked about. the school district may bring that up, or whoever, it could be the parent, whoever is the responding party may say, when it's time to put on my case, if I have a witness, can I just do my witness examination after the parent is finished with that witness? And the hearing officer will say yes or no. Okay. So it could happen anyway. And if you're in the hearing and you don't understand was said, you can just raise your hand and say, excuse me, could you explain to me what just happened? You can always do that. Okay, next page. This again is a little bit more of presenting the evidence. I have to keep the font at a certain level to make it accessible. So if it doesn't all fit on one page, I can't shrink it down tiny. If the hearing officer, this is an important provision. If the hearing officer determines there's insufficient evaluation data or insufficient evidence is available to make a decision, the hearing officer has the power to order the child to be further evaluated, and it would be at the expense of the school. Or they could request additional testimony on any issue. Like if they don't feel the testimony covered everything, they can ask for more. And that's important to know. And the hearing officer will also, I don't guess I'll put this in there, but the hearing officer will also ask questions. They may not, oh, did I say that? I did, didn't I? Because I remember telling you I liked it when they did, because I could tell they understood what was going on. But sometimes when you're putting your puzzle piece out there, you may not put it out in a way that hearing officer totally gets that you're pointing it to that. So when the hearing officer asks the questions, they're narrowing it down to what they need to know for their legal standard. Okay. Then it comes time after all the witness testimony and they say they're closed, they're done, there's no more testimony. Then there's an opportunity for closing statements. And this is where each party will give a brief summary and they'll tell them, you have 5 minutes, you have 10 minutes, you have 1 minute. I think it won't be 1 minute, but they'll give you a time and they'll say, summarize your position in a closing. It's time for closing statements. So then you're going to summarize, Your Honor, you saw the testimony of this, you heard this, you saw this, and I believe that this resulted in this being a denial of FAPE because this IEP was not reasonably calculated so that my child with his educational ability could make adequate progress within a year. That kind of thing. And you tell them, briefly what, again, that big picture, and you can cite and talk about the evidence a little bit. The responding party, which is the other side, can also give theirs. Most people do not waive this. They give their final oral summary. And sometimes the schools is, we don't believe the case has been made, or, whatever. They have not proven this by a preponderance of the evidence, whatever, but they'll have something to say. And the summary can cover the overall evidence, not every little piece. And they may present reasons why the hearing officer should rule in their favor, why you should rule for this. What does it mean for this child? What is the difference it's going to make? And no objections can be made by the other side. So if you don't like something the school's saying in their due process, you can't object to it. You have to listen to it. And if the school doesn't like something you're saying, they can't object to it. They have to let you have your closing statement. Now, the hearing officer can limit the time because they're in charge of making an efficient hearing, having efficient hearing, and they might not let you have an hour or two. If they tell you 10 minutes and you're almost through at 10 minutes, you can say, sir, could I have an additional 2 minutes to finish? And they might say, go ahead. So, I mean, they're going to be reasonable. The hearing officers don't want to be favoring either party. They want a full opportunity for people to get their evidence out. They just have the responsibility to not let the hearing just go on and on and on over irrelevant things. So they have to keep it kind of tight. Okay, next slide.
Joanne, I think
Yeah.
I think our next one's the conclusion, if I recall correctly. But We do have a question. Do you want to wait until we wrap this up real quick and then address one of the questions?
Yeah, I'll hear the question.
Okay.
What is it?
So, oops, it was related to this. It's, does the school have complete discretion as to the type of evaluation, if they were ordered to do a further evaluation, or, and or the exact test to use? Does the school get to decide that?
That just depends on what the hearing officer is wanting it. There's rules about evaluations. For instance, no evaluation can be a same evaluation generally can be completed within a year. So if they were doing an IQ evaluation, they asked for a WISC. If the child had already had a WISC, they wouldn't allow that. So it's the hearing officer is generally going to say what they want in that evidence. It's not going to be the exclusive decision of the school. I think it's going to be the decision of the hearing officer, and they may be as specific or as general. They may say, I just would like this child to be tested to determine. They have to say why they're wanting them tested. Maybe they're testing them to determine if they are in fact have Tourette's, or, you know, have a different, because sometimes you get competing evaluations where it's a battle of the experts, and the hearing officer could see that each party is slanting their evaluation to prove their case and it's conflicting. They could ask for a third one that's more neutral, by somebody neutral, not associated with the school or the parent. So I would have to say that would be left up to the hearing officer, but the hearing officer would have a specific reason for what they wanted to test. And I would say, no, the school would not have, I wouldn't say the school would have the exclusive decision unless they said, I just need an IQ test that is not one of these. But they should, I would think the hearing officer would be pretty specific about what they wanted.
Joanne,
That's the
isn't
best
there
I
like
can answer it.
this is Sharon, isn't it ironic? Sometimes it's 3 and 4 months out, 6 months out to get somebody to evaluate the child. So does the hearing officer, what do they do about getting it expedited? Or
You know, yeah, they would try. I mean, that's the thing. It doesn't happen. This does not happen a lot. When I was practicing, it happened one time in 10 years. I don't know that I've ever seen it happen in the 18 years that I've been at CERC. It's an extreme kind of thing. And our hearings aren't typically that, contentious, but I don't think the parent's going to have exclusive decision making, and I don't think the school's going to have. It's if the hearing officer determines they need more information. It would probably be based on what the information they needed. Now, I would think OSEP would be unhappy if they couldn't find somebody. And before a hearing officer did this, I don't know, they might have CERC reach out to a reputable entity. I don't know. I mean, I'm kind of making this up because I don't know what would happen, but that is a problem. But there are people who might expedite it for a hearing.
And then I like that you clarified that this isn't related to necessarily a parent or a school wanting to further evaluate the child. This situation would only occur if the hearing officer needs more information. If a parent wants the school to do additional evaluations, or the school wants the parent to consent to additional evaluations, that potentially could be resolved through other methods or as a result of the decision. In this situation, it's like, okay, you're a hearing officer. You've gone through this hearing and they have an issue, but nobody's presented the right evaluation data. Right.
And so it may be that they say, well, I can't really make this determination without this information. So I'm going to order this particular evaluation be done. The school has to pay for it. Now, I know the one time it happened to me, the hearing officer had a person and said, would either one of you object to this person doing the evaluation? I had no objection to them. They were a very reputable entity. And so, it could be determined based on maybe their backgrounds, maybe their, I mean, it could come up for a lot of different reasons. So I hate to be too specific, but it's not, it's going to be what the hearing officer wants.
Right.
Okay.
Okay.
All right, we already went there. Okay. This is sorry, I think this one and then one more then.
Is this, okay.
Yeah, I don't, this is what we hadn't done yet.
Okay, so the closing of the hearing, this is how they close the record is what this really means. And they do the closing statement, and it's going to assure in that closing statement that the hearing officer is going to obtain a copy of the record and make sure that all the parties receive it. So they're going to talk to the hearing officer, the court reporter about it. They'll talk about maybe they could bring up, I don't know exactly the words they would use, but they're going to use something to that effect of you're going to get a copy of this hearing. They may say, when will this be ready? Get some information from that court reporter. Then they're going to tell you, they're going to study the evidence and testimony carefully, and they will go through and they will actually cite in the record the testimony they're referring to. And that takes a while. It takes a while for a parent in a school to do it too. And they will read what the parent in the school cite so that they're not changing or, kind of slanting what the person was saying. They'll decide if that was what the person said or not. But everybody's going to really look at that record. They're going to render a decision within the mandated timelines unless an extension is properly granted. So they would talk if any extension had been requested to receive the an extension to get the briefs. I say it down here a little bit too. And they're going to state that both parties will get a copy of the decision, probably tell them how. They'll state that the decision is binding upon the parties unless one of the parties appeals it. And the language for appeal is either party aggrieved by the decision can appeal to the state in writing for a review of a decision for the appeal officer. That means we're a two-tier state. So we have due process hearing number 1 and due process hearing number 2. So there we have the hearing decision, and then we have appeal decisions. And if you're going to appeal it, it has to be appealed 30 days from the date the hearing decision is received. And they will either rescind it to you, maybe by computer with a acceptance that it was read. They'll mark it, whether it was read, or they'll send it by certified mail. Somehow they have to designate when the hearing decision was received, so they know if your 30-day appeal time process runs. Then they will ask if anyone is requesting an extension to receive the transcript to cite to in writing their proposed findings of facts or a brief or something like that. And then they will make a statement, the hearing is officially closed, giving the date and time. So once that hearing is closed, nothing that is said is put on the record. But when that record's open, everything that's talked about is transcribed. So it's a complete record of the hearing.
Yes.
And parents have a right to a copy of that, by the way. Okay, next slide.
Okay, we've got one more question. I know this is our last slide about at the appeal point. Is that when schools typically escalate to federal court if a parent
No,
files an appeal?
we have a two-tier system. Some states have a one-tier system. And ours is still, there's only like 6 or 7 states that have 2 tiers. And so we have the regular due process, and then we have a due process appeal. If they are still aggrieved, the party that is aggrieved after the appeal decision will take it to court.
So the appeal then, Joanne,
It's an appeal of the due process.
and then an appeals officer would review that.
Yeah,
Right.
an appeal officer, and appeal officers have to at least been a hearing officer for at least 2 days. We have 2 of them right now that can serve either way. We actually have more than 2 that could serve either way, but 2 that have agreed to. So it's a 2 tiers, and that in the appeal process, the appeal officer receives the transcript and they receive the evidence notebooks, a copy of the evidence of the parties, and then they read everything and they either uphold or clarify or do something with the due process hearing decision. So if you go to our website under due process, and it's up here down there, okcert.org, go to due process and scroll to hearing decisions. You can see them. We had quite a few last year. And so we gathered them by number, the case, and then the appeal, and they're there for you to read if you would like to give you an idea of what the decisions look like. They can look different based on the cases. And it's a 30-day review. So the appeal process is 30 days. And if they find that the procedural safeguards have not been followed or something like that, they might overturn it. Something like that. All right. So any questions that you have, I want to encourage you to read the regulations, because everything we do is in those regs unless OSEP tells us to do it a certain way. So reading CFR 300.507 through 300.536 gives all the rules about due process. The due process guidelines are very specific about what has to happen. Read those. They're on our website. The Oklahoma policies and procedures. You can contact CERC with questions, and you can also look on our website. I know our due process guidelines are there. There's other information about due processes.
And Joanne, just to kind of bounce off of that, like not every due process request goes to hearing. It won't, not every single one goes all the way to this step. And so sometimes this stuff does get resolved prior to hearing, which is why I think at the beginning we talked about, you know, phone a friend, call us if you're considering filing, just so that we can talk through what are the issues. Is this something you would, you know, alternate methods, not to prevent due process filing, but to kind of talk through what this could look like and what the processes are, because not every single filing gets here. A lot of them don't get here.
Well, hopefully, because of all the anguish we hear and the problems. Okay, so in our state, we have strengths and weaknesses. One of our weaknesses is that we don't have a strong parent bar. And so parents have a hard time finding an attorney that's knowledgeable enough to bring a case. And so we have many pro se filings. And it can be very overwhelming because you're asking a parent with very limited knowledge to understand legal proceedings and how things are done. And that is difficult, very difficult. So we try really hard. I mean, we try really hard to have upfront services to try to get people to talk, sit down, and work it through. If there's a reason that the parties are not coming together, I often see it sometimes as there's just a real discrepancy in how case law is being determined or what they're relying upon. Very few of our cases are actually huge legal cases. We did have a big legal case last year that changed our graduation standard. That was a big case. Most of them are people that are angry with each other. And I feel like people who understand the law, who are willing to listen to people, can sometimes sit down and work through this. Because again, I just want to say that FAPE standard is an IEP reasonably calculated to provide some educational benefit in light of the child's individual circumstances. It's more, before the Andrew case, it was defined in our jurisdiction as just more than de minimis. How much benefit? Just more than de minimis. Now they should have challenging goals, but they don't have to maximize a child's benefit. And that's really, really hard for people to understand. And it's not that hard. I mean, I don't know. It's very legal. Just put it that way. I think we are, do we have any other questions? I see something down there. Was that Rob?
No other questions, just A thank you from Rob for attending. This is the end of the 3-part series on due process. We do have another webinar actually next week on the 21st from a parent, all about the perspective of parenting children with significant disabilities. So make sure to register for that as well on the website and join us as you're able. And these will all be posted. The recordings of this series will be posted to our website pretty soon.
Thank you all.
Thank you.
Thank you.
Bye-bye.
Bye-bye.